Appreciate your being here. Jasmine and I tend to really talk about what's really happening out there. I mean, you probably have gone to CLE and they'll go say, okay, and they'll go through what the law is, what the cases are. We're going to talk about very practical, pragmatic things of what's happening. That gentleman, Josh, it's a pleasure to meet him. On the plaintiff's side, we represent the employer's side. We have very good relations with the plaintiff's bar and also the departments of labor. But when I say the nightmare continues, for the employer side, it's unbelievable of what's going on. Even before we get to our slides, I mean, you may have seen the paper the other day. People read the paper. But I think it was in Newsday, and I got calls from different people saying there's a landscaper in Stony Brook. We don't represent this person or the company, but the landscaper who's been arrested for not paying overtime by the Attorney General's office, owes $20-something thousand. We have a landscaper in our office that, probably owes 3 times that or whatever else it is. It's unbelievable what's going on out there. And the landscape is changing every day. And we're here to talk about what has changed, et cetera. Also, what I want to do, I don't know who knows labor and employment law, who doesn't know labor and employment law, whatever. We sort of do things, we get through all the material, but we're sort of a little bit showtime. So that being the case, those of you who know me, if you have any questions at any time, we don't want to wait to the end. If it's off topic, you say, I want to talk about OSHA, okay, we'll go talk about it. We'll get through everything, but I prefer that you be as interactive as possible. I have had, when I negotiate with unions, one union in particular has said to me that if I ever got paid by the word, I'd be a rich man. So, the advantage would be of you to stop me as quickly and as often as possible. And Jasmine has I appreciate that, and has done a tremendous job in not only putting this together, but being involved as a young attorney. Clients love her because she really gets to the bottom of it, and you try not to over-lawyer the situation. So it's a pleasure to be involved with this with Jasmine as well. All right, what's going on? You have your packets there. You can follow along the bouncing ball. What's happening now? Independent contractors, 1099s. The days of 1099s are basically over. We had a good laugh in our office last month. The governor came up with something new. We've been saying for years, because that's what's been going on. The reason that 1099s, independent contractors, are really frowned upon by the New York State Department of Labor unemployment insurance auditors is because for years we've been hearing that the unemployment insurance fund in Albany is $3 billion, with a B, not an M, $3 billion underfunded. Take a look at it. It makes perfect sense. Well, what happens is that, and we'll get to that with other slides, but people go and have to, if somebody makes $50,000 a year and somehow they lose their job, he or she loses his job based upon being laid off or whatever reason, the employer only has to pay for the first $10,500. So doing quick math, that's about $400 and some odd dollars that you'd have to pay a year for that particular person. But that person goes and files for unemployment. And that person can earn, I think it's $420, I think is the max now. I'm sorry?
I think it's $455.
$455? I'm not sure about that. Let's say we'll take that ballpark, but I think it's fortunately neither of us have that, not personal knowledge. But $420, so you have to make sure you get clients. $420 a week. So ballpark, $21,000 the person could collect, assuming it's extended to 52 weeks. And the company is, all they've done is given about $400. So the fund has been $3 billion underfunded. The governor this past week, whether, I don't mind being videoed, so I say basically anything with no filter. I don't care, I don't know if he's running for president 2016 or 2020, but certainly, all of a sudden saying that the $3 billion underfunded, great news, there's no underfunding, is interesting, and we had a good laugh about that. In any event, The 1099s, if somebody is classified as a 1099 or independent contractor, the government does not get their X dollars to the unemployment insurance fund. That's the practical implication of this. I mean, we'll go down what the practical test is, et cetera. But I'm here, I hope Jasmine is here, to give you what's really going on as of June 24th, 2015, what's going on with business, what's going on with the labor and employment community, what's going on with the agencies. You know, the agencies have basically said, hey, in the past, there's a 20-factor test that the IRS had. You know, for years, if an employer had 11 or 12 out of the 20, okay, they were considered an independent contractor. The auditors have come into our office and said, Glenn, Jasmine, if there's one or two, we're finding these people to be employees, and basically, good luck, and good luck at your hearing before an administrative law judge. So that's what's happening. It's, you know, so understand that even if one has an independent contractor agreement, it's really something that is being frowned upon. Their task forces, this goes all the way back to 2007. We'll talk about task forces in a second, and that's become more scary for our employers that we represent. But independent contractors, okay, the question is, from a general standpoint, if one thing that, you know, whether if you don't do labor and employment law, want to know, rather than the 20 factors, does a company have direction and or control over the person? If they have direction or control over the person, the likelihood is that person is going to be classified as an independent contractor. However, what I'm saying to you is the playing field is not level anymore, at least at the lower level.
If they have control,
No. If there's direction or control, they're considered employees. If a company has, Julia, direction or control, they're considered an employee and not an independent contractor. I may have misspoken, but they're not an independent contractor. And that's really the crux of what's going on in that portion of that. Jasmine, anything to add to that?
There's a recent case that we can go through called Keller v. Meary in the Sixth Circuit, and in this case it was a satellite dish installer, and the installer agreed to be an independent contractor for a company. However, he then sued for not receiving overtime, and the court went through an economic realties test, and they said that they would go through each of the 6 factors that they use in the economic realties test, which was permanency of the relationship, degree and skill required, the worker's investment in equipment or materials, the worker's opportunity for profit or loss, the degree of the alleged employer's right to control the manner in which the work is performed, and 6, whether the service rendered is an integral part of the alleged employer's business. And in this case, the installer was able to hire his own employees, decide when and where he wants to work, but the Sixth Circuit found that it should go to trial because the installer never turned down an assignment and worked full-time for the company for 20 months. Even though the installer was free to work for others, his location made it difficult to accept outside work, and the company provided him with the necessary training, so that went in favor of him being an employee rather than an independent contractor. And because the installer followed the work schedule of the company and the company guaranteed his work, that also went in favor of his being an employee rather than an independent contractor.
These days, if the Unemployment Insurance Division in New York. Yes, sir.
I just want to ask you a question on that. Did he have his own corporation or LLC?
He had his own company, yes. But because he only did work for this company, and on the side he maybe sold something here or there, but it wasn't much, the Sixth Circuit said you have to look at all these 6 factors, and in this case they found that there was enough facts going towards him being an employee rather than an independent contractor.
We have seen this locally, that even though they have, great question, thank you for asking that, even though they have their own corporation, John Smith Inc., if they're not invoicing, if they are really being trained, if they don't really have the profit or loss, if they don't necessarily hold themselves out to the public, websites, business cards, all these other kind of things. We had a company just recently in which they said, wait a minute, this person is definitely she has her own website, she has everything else. The company gave out, however, a business card that said Mary Smith, Vice President of company. And based upon that, they're saying you're holding her out to the general public that she is vice president of your company, whether she's doing whatever she's doing or not doing that. Boom, that's enough. So now that's an employee. Yes.
So you're basically, if they have the corporation LLC, they need to have a bona fide business with other customers.
Right.
Yes.
And sometimes I find that it's the employee or independent contractor who wants to be treated as a 1099.
Yes.
They want to get their 1099. Can you contractually provide that they're going to be responsible, and if you ever get audited, they're going to defend and indemnify? Is that legal?
No, that's not lawful because they can't necessarily agree to something that's is not statutorily permissible. It'd be the same principle of that you and I have. I work for you. Minimum wage right now is $8.75 an hour, and you say, okay, Glenn, come into my office. I really need a job. Thanks. I'm going to agree to go pay $7 an hour. I'm going to sign a contract in blood. You can't waive the statutory rights. So it's similar in that instance. But it really is becoming much more difficult to do that. What really needs to be done? I mean, if the Department of Labor, Unemployment Insurance Division, wants to hang their hat, they hang their hat on just several. It could be 2 out of 20. Having an independent contractor agreement is helpful, but not dispositive of that. Having invoicing is not that. I mean, if they don't invoice, et cetera, it's a problem.
You really need all the factors now to be considered an independent contractor.
Right. I mean, we have issues right now. We have a couple of cases. One several years ago that would put the company out of business. They are a small entertainment company that they tend to provide to nursing homes and assisted living basically entertainment. Somebody, a singer, a violin player, or whatever else it is. One person who was working for them, legitimately was an employee, left and filed for unemployment. That triggered an audit, and the next thing that happened is they came in and said, the 300 people who work 2 days, 1 day, 1 hour, whatever else, all those people should be considered employees. This guy was so far out of business, it was unbelievable. And the only thing that helped him, and this goes back several years before the $3 billion deficit, was that most of these individuals had a website and saying that they wanted to be, held themselves out to the public, John Jones magician for birthday parties, for this, for that, whatever. That kind of issue. Had business cards, had things like that, and where they were not exclusively working. In Jasmine's case, even though we're talking about Sixth Circuit, the Sixth Circuit is taking a position. Hey, you can have your own, vehicle. You can hire your own people. Good luck, but you're really only working 100% of the time for this particular company. So if we want to hang our hat, we're going to hang our hat. Our position here is to just inform you that there could be, legitimate 1099s. When a plumber comes to your house, he or she is not an employee. Okay? But that's what you have to look at it that way. And that's the way the Department of Labor is looking at that as a fine-tooth comb. You'll hear me say later on about the nightmare continuing. I might as well say it now. And we've told employers many, many times, as an employer, you're guilty until you can prove yourself innocent. No doubt. And look, we have a lot of employers who have issues. When we get to the wage and hour issues, we represent so many restaurants. It's like a bakery in our office. Take a number now. But what we're saying is, some of them are playing the game. But there are others that have no clue. We'll tell a couple of stories, do some war stories as we go forward. So, independent. Yes, sir.
Well, if you want a real life war story.
Okay.
And I'll be brief. My client, I represent some sheetrockers and framers. Mm-hmm. guy got a contract to do a job in Manhattan. He farmed out part of that work to another subcontractor with a written contract.
Yes.
That subcontractor then failed to pay his employees.
Right.
Employees.
Yep.
They came back to us with unpaid wages.
Yep.
We went to the Industrial Board of Appeals.
Yes.
And of course they hammered my guy, claiming, no, this guy was not an independent contractor. Despite the agreement, he's your employee, subcontractor.
Right.
Then the Ovadia decision came down.
Right.
I utilized that in my petition to appeal to the first department on 78. They shot us down too. So, and that was just a couple months ago.
Yeah. So yes, thank you for sharing. Yes.
So they still found that my guy was
right.
responsible for those other
I appreciate. Thank you for sharing, and thank you for that. It's a very difficult situation. So that's really evidence of the nightmare, continuing. People may have looked and said, "Oh, do I come to the CLE?" Glenn Franklin, Jasmine Patel are speaking. Is that the real nightmare continuing? But so I do appreciate that. Julie, yes.
Len, does this independent contractor apply also to counsel attorneys that are part of your firm?
I would have to say that of counsel attorneys, because of that relationship, it could be considered employees. Again, it depends. It's very, very fact sensitive. Okay. If you have a of counsel attorney who Monday is working for you and Tuesday is working for us and Wednesday whatever, if they're working for you primarily, I would have to say the Department of Labor would take that position that those people are employees, of counsel or not. And most of the time, when you have of counsel, and we have one of counsel, a person, once you pay, we have a gentleman, once you pay his, he needs a cell phone, it's an office, he's on New York City office, he's,
so you're not paying those, but you're paying them for the work they're doing.
That's correct, but also the question is, whose malpractice policy is he under? If he's under your malpractice policy, that would be enough to go, I think, to go and tie him or her to your firm as an employee. So it's something you really have to look at. Great question. I appreciate it. Yes, question in the back, sir.
How are interns supposed to be classified?
Interns. Well, we have the whole section on interns.
I can go to that now.
Yes, just a quick summary for interns. Interns right now are viewed at also, we have a monster case that we're actually handling. We'll talk a little bit about it. But interns right now are very, very difficult. It's perceived that those people should be considered employees and paid. The times of the unpaid intern are going the way of whatever, pick a car that no longer is on the road or something. I mean, that's brand new. The case, we'll talk about the cases that you have the wage and hour obtained interns. We have kind of crazy thing. Jasmine's going to relate to that in a second. There are 2 cases that are right now before the Second Circuit that we're waiting for any day. We're hoping any day because we have a company that is really, I guess I can talk what industry they're in, sort of. Yeah, we can talk about the industry. The industry. They're in the recording studio industry. And as you probably can figure out, the gray hair was from my oldest son in a prior life with doing the records and being a rock star, all that stuff, and having his own company. But when he started, he would go and be the guy that would there, hey, Brad, go get the pizza. Go across the street, get the coffee. Okay? That is a problem now. Sorry, that's a problem now. So the short version is that interns are certainly not 1099s. Interns are either not anything other than they don't have to be paid. They don't have to be paid. They're not employees. But to go and get to the intern, there are so many restrictions that you have right now that I don't know any companies that we have.
Basically, if you're a profit company, having interns is recently not been a good idea, and a lot of companies are going away from having unpaid interns because these agencies and courts are finding that their interns are really employees and should be paid minimum wage, overtime, and get all the benefits employees get. Nonprofits can still have unpaid interns. Profits, there's all these tests. The Department of Labor has one test. Courts, right now, the Southern District had 2 different cases. They applied 2 different tests.
We're going to go. I want to go through that because just to show you, it's the same. Well, the thing that amazed me when Jasmine was researching this, I thought, okay, The Eastern District says one thing, the Southern District says something else. I get it. 2 Southern District cases. 2 Southern District cases. Now going to the Second Circuit, you're saying, okay, different judges sitting on a panel, I would think, but they came across, 180 degrees different. So to answer the question on the intern aspect of it, why don't we go through the interns just for a second? Let's at least hit this thing. We can come, we'll come back to that. Gentleman in the back, yes, sir.
Come back.
What is the statute of limitation for the audit purpose or for a person who claims that I was not independent contractor but I was an employee? So that's first question. And the second question is, when temporary hiring agencies, when they hire some staff and then they depute to work for somebody else, in that kind of scenario, everything is controlled by those temporary hiring agencies. So, but the contract between the employee and the hiring agency as well as the ultimate employer is also independent contract.
Okay. Well, first question is, the statute of limitations, really contractual, is 6 years. The reality is it doesn't happen. Somebody is an independent. Here's how it really happens. Okay? I'm not supposed to stand in front of the screen so far. I guess I'm doing okay. But what happens is somebody's an independent contractor. They want to be, they want a 1099, they don't want to pay taxes, they don't want to do whatever it is, and somehow it's not working out. And what happens? That 1099 goes down to go file for unemployment insurance. That's what happens. Or something else happens and there's some kind of audit. So although it's 6 years, the likelihood is once that happens, it goes very, very quickly, sir, as far as how that's going on. Now, if they're working, I think I understood the second question, if they're working for other people and things, that's just one factor. Certainly a helpful factor, but just one factor that you have to look at as to what the circumstances are. I mean, if they are working for somebody on Monday and somebody else on Tuesday, somebody else on Wednesday, that's one thing. If they're working primarily, 4 days a week they work for such and such, 1 day a week for they're not invoicing the company, then, they're viewing that. There's a predisposition that the individual is an employee and not a 1099. So, as this gentleman said before, and has gone through the ringer with his client, you have that difficulty. Yes, Sharon?
What about joint ventures, when you have 2 similar professions and you're working with somebody and then you're actually paying half of whatever commission you get? For instance, I'm a legal recruiter. I have a client, they brought me the candidate. So now that's a 50-50 split. A client doesn't know what's going on. It's seamless there, but it's a joint venture. We work together.
Yeah, a joint venture, if it's something that you really have not the direction and control, but you really have a separate company, and from what the facts, and every fact pattern is different, a joint venture issue, as you're describing that, I would view that as really a business, 2 separate businesses as opposed to somebody being classified as an employee under what you're saying. In your circumstances, if you're working with somebody and doing whatever else, you have your separate company, you're having the merger or acquisition or whatever else, and you may be doing whatever you're doing. I don't see that as necessarily an employment relationship, but again, we'd have to go and find out a little more facts.
Can he bill me for his part of the fee if I'm the one who's collecting the money?
Yes, the more invoicing that you have, the more separation that you can show. The answer is yes. We can go talk about that. Certainly help with that. Yes, sir.
I have a couple of misclassifications before ALJ and appeal board.
Yep.
Finding 2 standards that they use.
Mm-hmm.
Means and results.
Right.
One standard that they use for regular people, and overall control for professional services.
Mm-hmm.
However, the difference between the factors that you're describing are pretty much the same.
Mm-hmm.
But I would like to point out that you can get an advance opinion from the Department of Labor,
Mm-hmm.
Which is helpful because if you are eventually determined to be misclassification, you don't get the penalties.
Mm-hmm. Thank you. That's very good. Good to share. Excellent. Excellent. No question. The advance opinions. The question is the timing of it.
Yeah.
That's always something that we always concern about. We have some issues. We do that sometimes with the U.S. Department of Labor on the wage and hour issues, and you hope that you want to say, okay, please, let's try to go move it up. But if you can get those that's helpful. Yes, sir.
How long does that take?
Well, that's the question. How when you've had that?
When I had that, I did it for one company. It took around 3 to 6 months.
Yeah. That's the
And
problem.
basically, the opinion said, at this moment, we cannot determine whether they are independent contractors or employees. We'll consider them independent contractors subject to further.
Right.
But you won't get the penalties.
Right. And also, sometimes I want to just go talk about it. It's related. Speaking of penalties, thank you, sir, for sharing that. What's related is sometimes you have a company that has only 1099s, independent contractors. They might be small, they might be this. So the problem that they also have is that they do not have workers' compensation at all. Once that happens, now you're talking about crazy dollars in fines and penalties. The fine and penalty for no workers' compensation is, am I jumping all over the place?
It's okay.
Thank you. It's like it's like you're being a TV director and producer. Thank you, Jasmine. $2,000 for every 10 days you don't have it. It's insane. The issue with unemployment insurance is there's no personal liability on unemployment. Company goes out of business, they go out of business. Now, sometimes, and again, being taped, I don't really care, sometimes the clients try to be cute. We're going to call ourselves, we're going out of business because, the rates are going to be too much or whatever it is. And so we're not going to go, ABC is now going out of business. And they think the same owners will call ourselves CBA, like the bargaining agreement, CBA, and they get hit with the same, they say, listen, this is basically either an alter ego, success, or whatever. We don't care what we call it. We're going to charge you with the experience rating. So any of your clients trying to go and think the fake left, go right, doesn't work. Not that you would ever recommend that anyway. But some people have come to us after the fact and we go, well, I don't know who's telling you that, but that's something to do that. Now, today, this is the only thing, I want to go back to workers' comp for a second. The only thing that is the bargain. Now I'm going to jinx it today, June 24th. You'll write this down and say, oh my gosh, something new. We have found, and you clients, you may be finding out for your clients, that if they don't have workers' comp, and the fee could be, the penalty could be $100,000. Again, personal liability. Right now, Albany, they're either in Albany, they're in Syracuse, they're in Binghamton, they're in Buffalo, all over. We've been fortunate, and sure you could be fortunate as well, in reducing the penalty. We've had some $100,000 reduced to $1,000 or $500. But right now, my opinion, say that publicly again, the government is a lot of times in the deficit reduction business. So right now, if somebody really takes a look at it and say, $1,000, we could reduce it to $10,000 or $20,000. I don't know how long this is going to last. But just be aware that right now, we found that's the one area where the government on the workers' comp penalties has shown a lot of flexibility and a heart. Most of these people are solos or small or whatever and had no clue. And the way to get that is to be able to go and get any penalties. Your client needs to go show that they presently have a workers' comp policy. A mea culpa letter, it's not a big deal. Hey, now here's a copy of the policy that we had. We didn't know my wife and cousin were the only employees. We thought that since it's family, we didn't know. We don't, please reduce the fee, et cetera, reduce the penalty. Yes, sir.
The bigger problem, you don't have the workers' comp and someone gets injured and the company is
right.
responsible.
No question. Yeah, I mean, that's a monster problem. There's the unemployed, the workers' comp, looking at Josh there, workers' comp fund, the, uninsured fund. But yes, they could be hit for, dollar for dollar. I mean, they go and have to pay the medical bills. So absolutely, that's usually the first question for, a small or new client. Do you have workers' compensation insurance? If the answer is no, then they need to get that ASAP. Unbelievably ASAP, because that's a real problem. Anything else? Okay, so let's go back to where are we going back to? Okay, this is something that's new. This is the severance area. As you may or may not know, we have some obviously labor employment people who practice in the room. But what you should be aware is there's no requirement under the law to give any severance to anybody. We recommend, although it's not on the chart here, we do recommend that if you're giving severance, that you have a release agreement. That's what you're buying for the severance. And the release agreement has to be proper. There's a longer agreement in which the Age Discrimination and Employment Act and other things in 21 days and 7 days, a rescission, just zipping through these things that really need to be in there if somebody is over the age of 40. If someone's under the age of 40, I can have a diff something a little bit less, but also something that should be as far as a release agreement. Jasmine, you want to go handle the new severance thing if you wouldn't mind?
Before, it used to be that employees would try and collect severance payment, but then also get unemployment.
At the same time.
At the same time, unemployment has caught on to that. And now they have a rule which says if you're getting paid, if you're getting a payment within 30 days of your firing or termination or whatever, then you cannot collect unemployment. But if you get that severance after 30 days, then you can still get both. So it's like a loop. If you're giving an employee severance and you want them to be able to still get unemployment, then the severance payment shouldn't be made until 30 days after the termination.
Okay? So that's new, and that's really what's that's going on. Yes, ma'am.
In an involuntary situation, aren't you supposed to give the employee rightfully the information that we're in unemployment anyways?
Yes, no, there's no, I mean, well...
No, but what do you do with that notice then? If you're giving severance, you tell them, okay, you can probably have to wait until after the...
That's up, but if somebody has ordinarily, if somebody has a severance agreement,
right.
I'm sorry, if somebody has getting severance, usually a release agreement, that's going to be up to the employee and his or her counsel, who usually will have, plaintiff's counsel may be there, and I should say plaintiff's, employee's counsel should, be that individual. And they can make a decision, hey, we would like to go and have our first payment. Mary Smith is terminated today, June 24th. We'd like our first severance payment to be made July 25th. So that's up to them. If they say nothing, whatever, yes, they can collect. We have nothing to do with that. You are responsible to give the notice, but it's not like you have to advise them to do that. We're just notifying you that we've had some people state that, hey, I want to be able to collect and I want to do that. Okay, this is what the new law is. You can do whatever you want. You're not violating the law. If that's what you want to do, then that's fine. Most of the employers have no, they don't care. If they're paying, $5,000 in severance, they don't care if it starts now or a month from now. They're happier it starts a month from now. The money's in their pocket. Yes, sir.
So would you clarify what that notice is that you have to give the employee?
The notice, well, all we're saying as far as the notice is concerned, you're notifying them if they're terminated. You're supposed to give them a notice that they've been terminated. But I think we're talking about, I'm not sure exactly what we're talking about. I'm really talking much more about if you are giving a severance, if you're giving severance to anyone. And I'm not talking about people are not going to sign, if you're giving somebody 2-week severance, people are not going to sign, a release agreement 98% of the time. But if there's anything else, then I'm saying that release agreement says that be the severance, and really the purpose of this particular slide, pardon me, is to go and talk about the time period.
So you don't have to give them notice
of their unemployment rights?
You don't have to give, you don't have to tell, you don't have to give that notice, not at all.
That's if they want to collect both, they need to be apprised of the law.
Okay.
A practice point, if the employee knows, the employee's sitting there really negotiating hard for severance, you tell them, listen, we're happy to give it to you, but you need to know that if you get the severance, you're going to lose it here. You're already getting a base. It may make it a little bit easier from the employer side.
Absolutely, yes.
To get the release, yes.
Absolutely, yes. And to go and say, okay, look, you want X dollars. If you collect unemployment insurance, you're going to get Y dollars. It's legitimate from the state, and we don't want to go and pay twice, and this is what we have. And, we're happy to do that. Absolutely, yes. From a practical standpoint, very, 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 very true. Excellent. Okay. Effective October 1, 2013, if employers fail to respond in a timely or adequate manner to a notice of potential charges or any other request for information, the employer may not be relieved of charges to the account. It was I mean, it's gone back and forth. I've been practiced, since Christopher Columbus. So, but it's gone back and forth. Is that, you had to go respond. You didn't have to go respond. You had all these employers through years. You had to respond. So we're just going to say it's layoff. Now, I mean, it's just idiotic. Then for a long time, you didn't have to. If you did not want to fight, contest unemployment insurance, you wouldn't have to even respond. You would tell the employer, you don't want to contest? Terrific. Go and put it in the drawer. Don't even respond. Now they're going back to saying that you do have to respond.
You have to respond and speak truthfully, because if the employee collects unemployment and they shouldn't have, those charges that you paid out, you're not going to get back. So if unemployment finds that your ex-employee collected $2,000 and whatever percentage of that you paid out, you're not getting back, even though the employee is giving it back.
Yeah, and it's a little confusing to us because we're only paying $400 and something for that. So
but the penalty is so that's your penalty, $400 something.
Yeah, and they may go charge you an experience rating. So, it's unclear. Again, we get calls, hysterical clients at times saying, "Oh my gosh, Mary Smith's going to collect $20,000." Yeah, but it costs you $400, as we made mention at the very beginning. So, it's not. They have to understand that, and when and you have to educate your client to make sure that they understand that. Now, I have to tell my McDonald's story on unemployment insurance. We're going to do that. So we don't represent McDonald's, but it's a McDonald's story. You can put anybody else you want. So here's what happens in real life. So Mary Smith, we use Mary Smith this time. We'll use John Jones this time. So John Jones is an employee. There's no question of independent contractor. He's an employee. John Jones steals from the company on videotape. On videotape. Okay, not this videotape, a videotape. So he steals, and John Jones goes to file for unemployment insurance. The client is adamant, aggravated. The client goes down, fights the unemployment insurance, goes down to, locally to 400 Oak Street and down here in Garden City, and wins. Of course they win. It's misconduct under Section 593 of the unemployment insurance law. However, John Jones, we'll go and walk in front, walks down and gets a job at McDonald's. John Jones is told 2 weeks into that job, John, you're putting too much salt in the fries, and nothing against McDonald's, but you're putting too much salt in the fries, and you're not that fast on the cash register. So we're letting you go. John Jones, because he's let go for not misconduct, guess what? The client who was stolen from is charged a percentage of the unemployment insurance. Welcome to America. Okay? Clients flip out. What's happening? It's counterproductive. So a lot of our clients are saying, I don't want to bother. I'm not going to take the time and effort. I just am not going to take the time and effort. I'll go and say lawfully what happened, and I still have to be careful. I wouldn't use the word theft ever. I might use misappropriation or negligent handling of cash handling procedures, or whatever. You don't want to be a defendant in a lawsuit. But you go and have that. They say, let them go. We're not required to go down to the hearing. If they get it, they get it. They don't get it, they don't get it. But it's just something that frustrates and aggravates clients to the nth degree. So that's my unemployment insurance McDonald's story. Okay, what are we up to? Well, go back just for a second, and that is, it's now $10,000. The first $10,000, I made reference to it early. The first $10,500. So somebody makes $100,000 and they make $10,600. It's the first $10,500 that the employer is charged. I said 4%.
Percentage of that.
Percentage of that. For 4%, it costs them $400 and change a year for that, and it's going up. Next year it'll be $10,700. Is that they'll be able to do that? Mm-hmm. Okay. All right, my wage and hour update. I mean, it's unbelievable what's going on. So let's go talk about wage and hour stuff. Now, some of you may know this. I apologize. Some of you may not know it, but really, what's happening today is when we talk about the nightmare continuing. Those of you who represent restaurants, there's a task force. It's not if a restaurant's going to be audited by the U.S. Department of Labor. It's when the restaurant's going to be audited. So you have 3 different places that somebody can wind up with a claim for overtime. or minimum wage, mostly overtime issues. In New York and federally, you have to pay time and a half after 40 hours of actual work unless the employee is exempt. All right, let me take 2 minutes out and talk about what exempt employee is. To be exempt, and I'm seeing all these things now. I'm laughing. These emails coming across. From different companies. Be prepared for the new changes in the wage and hour law. Doesn't affect New York. Doesn't affect New York. So I'm laughing that we're getting these. When I say it doesn't affect New York, we haven't seen everything. But right now, to be exempt from overtime, an employee must be salaried. What does that mean? He or she cannot be docked. If that person comes in 2 hours late or leaves 2 hours early, you can't say, Jasmine, I'm going to pick on you. Jasmine, which never would do, but Jasmine, I'm docking you 2 hours for that. Okay? You lose the exemption. So salaried means salary. The person works 17 hours or 77 hours, that's their salary for the week. Plus one of three things. Either the employee supervises 2 or more full-time people or their equivalent.
If you're in a jurisdiction that requires a verification code, please write the following code word down. Index. I-N-D-E-X. Index.
Question, sir?
Yeah, what about the somewhat common practice in law with holding paychecks until associates end their time sheets?
Okay. Technically, the answer is you can't do it. Practically, I don't think there's going to be. If they make a claim for that, they go to New York State Department of Labor. New York State Department of Labor may say first offense, don't do it again. They may say it's a $500 fine. Although when you say yesterday that you see a landscaper that owes $20,000, that the Attorney General running for governor, whatever he's doing, is now getting press. I was stunned on that. We've seen everything. We've seen prevailing wage things. All of a sudden, it goes to the criminal. But it is that. So ordinarily, the answer is no. You don't have to pay them. They're not manual workers. You don't have to pay them weekly under Section 191. So you don't have to pay them weekly. But yes. So
withholding wages, deducting, taking money out of their paycheck is never a good idea. You cannot deduct from the paycheck, even hourly employees.
So going back to the exemption for a second, and we can go and follow up if you'd like. But going back to the exemption, they have to supervise 2 or more full-time people or the equivalent. All right, meaning they have a right to hire, fire, recommend hiring, fire, and that must be their primary duty. So one of the investigators at a small restaurant, one of the investigators who I deal with for over 15 years, she's great. I say to her, listen, you're charging this. Yeah, the client came in and they didn't pay the overtime properly, but this person's a manager. You got to give me credit. Glenn, I can't give you credit for this. I understand why you can't give me credit. We went to the restaurant, small restaurant. Your manager took our order, cooked our chicken and fries, rang us up, brought us over. That was not he called him a manager, but that was not his primary duty. If we have a receptionist who answers Franklin, Gringer Cohen, may I help you? Hopefully she does that, right? But if she does that, and I give her a card that says Vice President in charge of communication. That's not going to fly. She doesn't have the right to hire, fire, or recommend hiring for her primary duty. Issue 1. Issue 2 is the administrative exemption. Hey, it's somebody like a controller may not supervise, or director of HR, or something. That person really may, but they exercise independent judgment rather than doing things of a routine nature. That's the terminology. Independent judgment rather than doing things of routine nature. So that person is administratively exempt. Still don't have to pay overtime to that person. But they can't go and say, okay, I exercise independent judgment. I know to pay Glenn Franklin's firm last every month. That's maybe true, but that's not really exercising independent judgment. People are really, at a higher level. And the third is professional. Attorneys, CPAs, chemists, doctors, other professional licenses. Could be executive chefs at a high level, baseball players or actors or sport. those people are also exempt. So, absent that, you have the departments of labor now. It's really now it's a challenge right now. Not even a challenge, not that word. It's really a contest between three entities. The U.S. Department of Labor goes back for wage and hour. That's their jurisdiction. They go back 3 years. The New York State Department of Labor goes back 6 years. The plaintiff's bar goes back 6 years and can charge attorney's fees against the employer as well. Whoops. So if you have someone who might be let's just take an undocumented dishwasher making $10 an hour for 50 hours. Hey, I'm paying this guy $500 a week. That's not going to fly without showing that they paid overtime after 40 hours in a week. There are ways to go and pay that person $500 a week properly. But without the records, departments of labor and the plaintiff's bar say, guess what? You are guilty until you can prove yourself innocent. We do that. So what happens? You go to U.S. Department of Labor. Let's take the U.S. first. We were there yesterday. And they go say, where are your records? Well, maybe they have good records. Usually what happens, we get involved, and all of a sudden, after the fact, we educate them, and they're now time cards. Time sheets that say 8 to 4, 8 to 4, 8 to 4, 8 to 4, are worthless. They have to be an accurate reflection of the time. With a client of ours, also, who did it right, $10 an hour for the first 40, $15 an hour for the next 10, that's $550. 400 plus 150, even I can do that arithmetic. However, they felt bad. No good deed goes unpunished. We'll live our lives like that. But had a client come in screaming, not at us, but screaming. Why? Some of their employees, if they left 2 hours early or if they came in 2 hours late, that felt bad for them. They said, this guy's making $550 a week. We did it right, but he can't pay his rent. So if he came in 2 hours late, we're not going to bother with that. There's an audit. U.S. Department of Labor took the position. You didn't do it dollar for dollar. Here's a bill of $70,000. One of the steak restaurants, that who shall remain nameless. Flip it. They're going, so now you're telling us we now have to dock them. Yes, you do. Okay. Read some reality stories. We had five restaurants, shouldn't say, 5 coffee shops. U.S. Department of Labor comes up. Originally, it's $300,000. When we go back, it's $160,000. Before I get there, this is if you represent companies, this is not a negotiation like a discrimination case. I want $100,000. We'll give you $2,000. We'll take $80,000. We'll give you $5,000. Doesn't work that way. You have to be able to say, hey, the employee did not work 67 hours. He really worked 54 hours. You have to give us credit for lunches. We were closed for Hurricane Sandy. She went back to the country for 3 months. We have a situation, he was in the hospital, his records that he was such and such. Whatever that is, that's how it has to be reduced. It's not a typical negotiation. You have to have that. How many times have we had the situations we had a paving company, plaintiffs' attorneys we have a good relationship with, but they took the position. They worked 52 weeks a year paving people's driveways. We went, it's 8 degrees and snowing, and they're not paving anybody's driveways on January 23rd. You know, I mean, we had records that we had. So, I mean, you have to deal with that. You know, the car wash industry. They close when you have that. We have to show the departments of labor and do all those kind of things.
Weather records, sunrise, sunset records, anything to show that they can't work.
I mean, these are practical, hopefully, these are some practical information we're trying to give you. So, of what goes on, both on the plaintiff's bar and on the employer's side as well. So, because it makes sense, because if you can have a relationship. So, U.S. Department of Labor goes back 3 years. New York State Department of Labor is very interesting right now, what's going on. It's a tremendous change in the past year. It used to be you run down there and the client, they do you give you a recapitulation sheet, say that the client is owed $57,000. Okay, you owe $57,000, right, wrong. You go and you speak to the supervisor or whatever, and you try to go see where you are. I started to tell the coffee shop story. I have to come back to that because it's very interesting. And that is, now you can't do that anymore. It automatically comes to what's called a compliance conference. You have to ask for a compliance conference. It's not required under the law, but you have to ask for the compliance conference. I think we've had only one time, maybe, that they said they're not going to do a compliance conference, and my blood pressure went through the roof. But 99% of the time. And it's a settlement conference. You go in, either in Manhattan or New York or locally, and you have somebody from Albany or somebody from Buffalo, administrative law judge. It's a settlement conference. And my advice to clients, and hopefully you have to give your clients too, you have to settle at that level. If you do not, here's what you have. It's unbelievable. This is America, sort of. You go and say, hey, we're not settling for $57,000. We've got this, that, and the other thing. They go, great, don't settle. We will go and have an order to comply, and you'll come to Albany in 2018, 3 years from now. However, we can charge, a lot of times, 25% liquidated damages. Because you're fighting us, we now go charge 100% liquidated damages. And by the way, we're going back, today's 2015, to 2009, 6 years ago, and we're charging 16% interest from 2009 to 2018. So before you're going up to Albany, with probably no records or whatever else, the $57,000 is $157,000. Okay? That's the reality. I don't know if people do CLEs like this, but that's the reality of what goes on, and that's something you really should notify your client. We had our St. Patrick's Day insanity where we went in, and our client had a major mess where it was over $200,000 they paid out over a period of time. 3 people, however, weren't part of that original audit. Instead of going and saying, we're not part of the original audit, what do? They say, you now have a time clock. Sorry, let's get rid of this for a second. There is a time clock, but you made us punch out at 4 o'clock and we worked till 6. Almost impossible to defend that, by the way. You have to disprove a negative unless you're going to put video cameras over there and keep them forever. And the second aspect of this is my favorite part. Hey, Jasmine, you want to go tell what kind of company they are?
Our client was they dealt with jewelry. They set jewelry. So these employees claimed that the supervisor made them punch out and either continue working there or bring the work home. And so what they were doing is setting diamonds. So we're like, what are they bringing home? Diamonds? I don't know.
It was, the Department of Labor goes, what?
That's what they say. You have to disprove it. It's your burden.
So it's very difficult. So they wound up, we wound up for a company like that. By the way, the supervisor who supposedly told them to punch out was no longer there. He was the brother of one of the workers that was making the accusation. The Department of Labor just goes, well, listen, we're here to settle the case. So, yeah, they could have, rightfully, they could go and fight this, but they're they settled for like less than $20,000. It is what it is. So, what clients can do though going forward? So going back to there are ways that, again, the pragmatic things that we're going to go leave the department, the wage and hour stuff, I guess, in a minute. But one of the changes. Let me backtrack. U.S. Department of Labor has now lost some cases to the plaintiffs' bar and the New York State Department of Labor. We're inundated the state, and we've very little U.S. Why? Because people say, I've worked 6 years. I'm not going to just go get 3 years back. I'm going to get 6 years back. So the U.S. Department of Labor has taken a different posture. The New York State Department of Labor has been issuing liquidated damages of 25%. So if you owe $10,000 at the New York State Department of Labor, now they're saying you owe 12.5 to the employee. Forget about the penalties yet, 25%. U.S. Department of Labor is saying, okay, we're getting beat. We're getting beat here. We got to get more cases. So what they're saying is, by the way, this is Washington, not local. Herb Mill Jonah is fantastic, and his whole organization fantastic. This is Washington telling the local office, hey, you got to charge 100% liquidated damages. 100% liquidated damages? Why should I settle anything at 100% liquidated damages? Yes, you robbed the bank. The most you could get is 10 years in jail. So we're going to offer you a great deal, 10 years in jail. So so you have to, again, negotiate down the other aspects other than liquidated damages. Going to my coffee shops, however, this guy wound up owing $160,000. There's a big smile on his face. I go, George, this is a lot of money still. Well, Glenn, I appreciate how much you brought it down and did this and that and the other stuff, but you don't understand. It cost me $90,000 a year. We're open 24 hours, 7 days. It costs us $90,000 a year to feed my employees. I feed them, I give them drinks, whatever they want. Going forward, they're not getting a glass of water. So in 2 years...
There's not going to be a fountain or a sink or something.
Right.
OSHA.
I mean, right. When I say not got a glass of water, they're not getting right. I mean, you have within OSHA regulations. Thank you, Jasmine. But what we really was saying is that in 2 years, hey, they're not required to do that based upon that because it's not considered retaliation. Did it for everybody. So he was able to. So there are ways to do that. I'm not saying that's the best way to go do it, but legally, there are ways to go forward if the client gets hit with a number. They could go, somebody's making $17 an hour, you could reduce their wage going forward prospectively to $14 an hour. Pay them the overtime, you're paying them $14 or $12 or whatever the number is. So all of those kind of things are going on. But the U.S. and New York State Department of Labor are going to whatever. Now, one other thing you must know. The U.S. Department of Labor, you can say to them, hey, by the way, come back later. New York State Department of Labor, they say if you don't allow them to come in and speak to the people, you're going to have a $10,000 fine. So our clients that know us, usually it's clients, our clients are in compliance, but the new clients, when they call us, I'm saying, who's there, U.S. or New York? You have that stuff. Now, again, the last thing is the plaintiff's bar. You have somebody who may not be documented, but that person still is able to go and collect money from either U.S., New York, or on the plaintiff's bar, and the employer is responsible for his or her attorney's fees and the other side's attorney's fees. There are too many law firms out there that are doing the following. Let's fight it to the United States Supreme Court. That's one thing if you have the documents, you have everything set. But those law firms that are doing that are raising the cost to the employer because they're forcing the plaintiff's bar to do more. Oh, sorry. Look, we have to... So... From a practical standpoint, if a client doesn't have, records or doesn't have everything else, the practical thing, the right thing to do in our estimation for the employer is to try to get it resolved as quickly as possible and put the company in compliance. It's not so quick because you still have to have, you have to have court conferences, you got to have that. But as opposed to go and we've seen a lot of things go on. All right, you probably know that the minimum wage is going up to $9 an hour. Come December 31st. You also should know, I don't know if we have that. Okay, we'll do that in a second. You also should know, I'm sorry?
Tip credit?
Yeah, it's going there. Okay. You also should know that the tip credit, so right now, wait staff can go and get paid $5 an hour as long as they average tips of $3.75 an hour to get to minimum wage, soon to be $4 an hour. Delivery people, this is where it's a mess. Delivery people, it's $5.65 an hour. Some in the car wash industry, it's $5.65 an hour. They're all over the place. You can still do that. But the wait staff, though, is going up.
No, everybody's good. There's no more different classifications.
Okay, so thank you. So starting on December 31, January 1, whatever it is, I think it's December 31.
December 31st, yeah.
Yeah, that tip credit is now going to $7.50. Restaurants are going nuts. It doesn't seem like a big deal, except it's a 50% increase. And the practical impact What's going on is some of the companies, some of the restaurants that we know are saying, we're going to the Chipotle model. We're just not going to have wait staff. We're going to just have, we're going to have self-service. So I don't know we don't know what impact that is, but just again, if you represent any kind of restaurants or any kind of tip credit things, that's going on. There it is, December 31. Okay? Questions, comments? Anybody? Yes, sir.
I have a question. Especially in fast food restaurants, there are delivery boys who pick up the cycle and deliver the food at the...
Right, delivery workers, yes.
So, but their hours and everything is controlled by the restaurant owner. But they are basically not directly employee of the restaurant. But from whatever discussion we had now, whether they will be considered as employee of the restaurant owner or independent contractor?
Oh, no. They're not going to be considered independent contractors.
They're going to be an employee.
The delivery workers are going to be considered employees. In addition, what happens with those people is that they have to be paid to make sure they have a minimum wage. Now, there's another factor there with delivery workers. We'll take 2 seconds for that. If they're doing more than 20% of their work is non-delivery, hey, go, you're a pizza guy, go start making pizza boxes. Go help cutting slices. Or more than 20% of the time, they lose the tip credit. We have a federal court case right now. We lose the credit. Instead of paying $5.65, you have to pay $8.75. It's a $3.10 an hour is a monster amount. Understand that all those 3 things we talked about, U.S., New York, and the plaintiff's bar, or the federal court case, I should say plaintiffs, but federal court cases, those cases, there's personal liability, not dischargeable in bankruptcy. What other good news can I give you? The nightmare continues. Yes, sir.
Personal liability for who?
Personal liability for the owners, and also I think it's for, we've seen everything else.
Anyone who could be defined as an employer, so...
It could really be construed as somebody who's really running the restaurant, even though he or she may not have ownership interest. We have seen that, yes. So the employer, either absentee or there's personal liability to that, both corporate and personal liability.
Investors in the restaurant that are owners, but they're not taking an active part in management.
Congratulations, they're in.
Yeah.
The nightmare continues. Yes, sir. Yeah, BCL, right, 630. Yes. Yes. So you have BCL at 630 as well. Yes.
A recent amendment now makes that applicable for LLCs too. Provide a written notice within 60 days of the termination.
Yeah. So you have that, and you have both U.S. and New York from the agency standpoint prepared to do that. I've seen everything. I've seen the U.S. I don't know if it was U.S. or New York. We had a diner that we represented, and the diner went out of business, and they still went after them. So they have to understand. And look. 1 second, sir. What I used to say, I talked about this yesterday, and I can't say it anymore. I said this to U.S. Department of Labor. We always used to go tell people, okay, look, here's 2 things. Nobody's going to jail, and this is not putting you out of business. We can't say that anymore. I can't say that. I've said that up to yesterday. I used to say that. But, the numbers are so astronomical and everything else, it becomes crazy. Yes, sir, again. And then 1 second there. Yes.
What is the statute of limitations on this stuff? And 2, if you have a client who's got a mess from a number of years ago, are there any voluntary compliance programs to get this resolved?
Great questions. The first question is, it's a 6-year statute of limitation. I can't believe how many, some reasonably decent-sized companies, small, medium, and whatever, do not keep their records. So the first thing you have to tell them is you have to keep their records. Okay? And what sometimes happens is also, when we're talking about that, you have individuals who may be secretarial staff, they're not punching in, or whatever. It's their white collar. Those people, many times, are non-exempt. And when they're leaving, they're keeping their time on their little calendar that they have, or whatever, used to, handwrite it. Now they keep it probably on their iPhones or whatever else, or smartphones. But, yeah, so it's 6-year statute of limitation. The voluntary compliance, there's really no voluntary compliance set up. But here's the real dilemma. And we've had, we had an accountant send us a client in which they weren't properly doing right. They have not been hit yet by anybody. No audit, no nothing, whatever. They had to make a decision. They could be an ostrich, put their head in the sand, or try to do it right. If they try to do it right, every week they're doing it right reduces the statute of limitations. But you still have that. The other aspect is to go and say, okay, we're going to go and take a look at what we really owe. If we owe $50,000 total, and we go and do it right and pay it, we can pay it over a period of time or whatever it is. If we get hit, understand that New York State is looking at 25% liquidated damages. U.S. and the courts at 100%. So your $50,000 is going to be $100,000 before legal fees. So it's a tough pill to swallow, but that is really another aspect of it and what happens. We tell them it can't be a Monday morning quarterback. If they decide that they're going to do something like this and make changes and to be that, and 2 weeks later somebody else makes a claim, you have to go in with your eyes open. You can't go and say, oh, I should have gone and done it right, or I shouldn't have done it because now I got hit. Follow up? Yes, question?